Next, what if the person was single or not in a domestic partnership at the time of death? In this case, the estate passes down through a strict family order. First, to the person's children or their descendants. Second, if no children or grandchildren, then it goes to their parents. Third, if no children or living parents but issue of parents such as siblings or issue of deceased siblings, then the property goes to the issue of the parents, which means siblings or issue of deceased siblings. Fourth, if none of children, parent, or issue of parents survive, but more grandparents or issue of grandparents, aunts, uncle, or cousins of decedent, then the estate goes to grandparents or their descendants, aunts, uncles, and cousins. Fifth, if none of the children, parent, or issue of parent, or grandparent, or issue of grandparent survive, but spouse or domestic partner with children, parents, or issue of parent surviving, then for real property attributable to the decedents of predeceased spouse, partner, who died with 15 years or less. For personal property attributable to the descendants' predeceased spouse, partner, who died within 5 years or less, goes to issue of surviving spouse, partner, or, if none, goes to surviving spouse, partner's parents, or, if none, then goes to surviving issue of deceased parents of spouse, partner. Sixth, if no one qualifies under any of those categories, then the estate goes to the next of kin. And if there's truly no next of kin, the estate goes to the state of California. So, what's the takeaway? If you die without a will in California, the law chooses your heirs. Spouses, children, and close relatives inherit based on a fixed order. But without clear instructions, your true wishes may not be honored. That's why it's so important to plan ahead, especially if you want to protect your loved ones, avoid legal costs, and make sure everything is handled the way you intended.